दोस्तों, online gamings. The gaming industry dealing with rummy, poker, fantasy sports, and companies like Dream 11 and Jungly Games, Gamescraft were all dealing in making tons of money by inviting youngsters to play these games, give them a lot of money in the hope of making some profits on the pool staked by them in these games. When DGDA issued notice to Gamescraft with a demand of 25,000 crores, Karnataka High Court had stayed that matter. But at that time, I remember having made a video saying this stay order is debatable because there were three issues raised by industry in this. First, they say this is a game of skill and this cannot be equated with gambling. Second was, well, all these games are not actionable claims which could be taxed under Section 7 the schedule under GST law. Third, the valuation. He says there is no question of taxing the entire consideration, that the money pooled by the users and the prize money pooled by the company. And therefore, they say, no, this can be taxed only on the differential of profit. Whatever the tax can be levied only on that. Supreme Court examined this question. And first, Supreme Court said that the companies have raised that this will lead to a lot of commercial hardships. Their income will be reduced considerably and there will be heavy tax incidence. Therefore, they challenged on the three parameters under Article 14, 19, 2021 and 265 of Constitution of India. Supreme Court ruthlessly rejected this argument with one-liner: commercial hardship or reduction in profits or increased tax incidence by themselves cannot be a ground for rendering a fiscal measure as unconstitutional. Therefore, Supreme Court rejected this ground. Then they say that the industry lawyers argued that the government has taken a stand that GST is payable on the full face value of bets and deposits rather than platform commissions or gross gaming revenue. However, the Supreme Court again said that both these considerations constitute an actionable claim. An actionable claim is taxable under Section 7, read with Section 9 under GST law. Therefore, there's a forward tax payable on the entire amount. On the ground of whether this full face value of the bets and deposits could be reduced by any other consideration, Supreme Court noted in the GST law, there is no statutory rule that allows any kind of deduction from actionable claims. Therefore, the Supreme Court, by reading and holding constitutional validity of sections 2 subsection 31, 2 subsection 52, section 7, 9 and 15 of CGST, as well as Rule 31A, 31B and 30C, held all these provisions to be constitutionally valid. Therefore, this contention of the companies was also rejected. Now, the company also said, are you going to tax the activity of gambling simpliciter? Supreme Court examined this in many paragraphs as a very long judgment involving 50 petitions. They said, no, we are not taxing gambling as simpliciter. We are taxing the actionable claim that this transaction constitutes within the framework of GST mechanism. So even this ground was accepted. Now, one more ground was raised. Look, these kind of companies, they are platforms. They are intermediaries. Users come, put money, they play bet, they make money and go. And therefore, they are only intermediaries. Supreme Court examined this in detail, whether these online gamings were genuinely intermediaries. They came to a conclusion, no, you are not intermediaries. You are suppliers of actionable claims to the users. Therefore, you must pay tax. And hence, they said all these games they by constituting this as gambling, they also constitute actionable claims. Therefore, the tax should be paid. Now, there are a number of show cause notices issued to all these 50, 60 companies who went to Supreme Court. Now, Supreme Court have said that these show cause notices shall be dealt with only under Rule 31A, 31B and 31C, dealing with valuation. That is, Supreme Court was so ruthless on this kind of games that they did not leave any leverage with the revenue officers or with the petitioners. They say you examine the deductions or valuation for the purpose of taxability only as per 3 rules. However, the Parent Act, the Promotion and Regulation of Online Gaming Act 2025 is still under Supreme Court's scrutiny. And what is the scrutiny? Scrutiny is regarding Parliament's power to regulate skill-based games. So whatever future ruling could happen, it may reshape the digital entertainment law and taxation policies. Now the question comes, what are the options? The total demand, it is gathered, is 2,50,000 crore by way of tax only. There's an interest automatic, 18 or 24, and there's a penalty. Now, all the show cause notices have not been stayed by Supreme Court. So, this show cause notice limitation, the 3 months, etc., will also have some play. But based on Supreme Court ruling directions, now the show cause notice have to be adjudicated all across India. I have read many articles in the morning on this issue and a lot of expert opinions also, and I also have my opinion. I think the honorable bench by Justice Pardiwala and Justice Mahadevan, I think they are the biggest experts in taxation. We have learnt GST reading Justice Pardiwala's judgment from Gujarat High Court and even in Supreme Court, and we have never found any deficiency in those judgments. So the industry may have been advised by senior lawyers, let's file a review, let's refer to a larger bench. Well, I don't think anything is going to work. Once a division bench of Supreme Court upholds the constitutional validity, it is very rarest of rare that a larger bench will say that the constitutional validity is not there. These are unconstitutional. Now, the industry can delay. They can take time in filing show cause notice replies. And they can go into adjudication. They can file appeals, as may be advised by most of us. We can make a lot of money. But they have absolutely no choice. The more they delay, the interest meter will continue. They can hope that they're filing a review by forcing the case referred to a larger bench. They may buy some time. But there are consequential offshoots of this action for delaying tax compliance. Now, what happens to the industry? This industry has lakhs of crores of venture capital. So all those venture capital funds are going for a 6 because these companies will have to pay tax, 10% retrospectively additional with interest and penalty, and that's 2,50,000 crore plus. Plus, they will have to rework their costing. And the new rules come from 1st May, already have been enforced from 1st May 2026 as per the Act. So until the Act is quashed, the rules continue. So now with 28% tax on full value, I don't think any lower middle class fellow is going to go and play games by paying 28% tax. That's a lot of money. So only the hardcore gamblers who cannot live without gambling will play games. And they have a lot of employees. They will have to search for a job. Now, notwithstanding whether they do online gaming domestic or from outside, so they might say that the POS is different. No, the POS for gaming will be the person who makes in India, that is India. Therefore, 28% tax will have to be paid. Well, friends, the judgment is worth reading. How did the Supreme Court, I have read the whole judgment, how did the Supreme Court approach this particular matter? And I, for one, as a lawyer, fully endorse this judgment. These kind of games that involve pure gambling, notwithstanding, I mean, when you play a poker, what is skill in this? Even when you play rummy, what is skill in this? It's pure gambling. You are playing this to make more money, and this money is contingent of your winning. And that's what Supreme Court said. This whole factual transaction constitutes an actionable claim which is taxable. Therefore, on the constitutional validity of various articles, including Article 265, various sections, including Rule 31 ABC of the CGST rules, and on the full consideration value, taxability or not, commercial hardships, increase in tax indigence, loss of employment, Supreme Court did not give any favor to these 50 petitioners. Well, it is for the government, if they can help, if they can create a settlement commission and make money, or the companies can declare bankruptcy. Bankruptcy is the biggest course of action they have. They can go into insolvency law, IBC, and file for bankruptcy on their own. Then government cannot do anything. Now, whether the directors of this company, if most of the companies are private limited companies, whether directors will have a liability under Section 137 of CGST Act, lawyers will have to examine. So let's wait and see. Interesting video you also watch. I will also read further. If I need to make any improvement in this video, we'll make another video. Thank you so much. God bless you.